Assalamualaikum warahmatullahi wabarakatuh. We can continue about our lesson. That's day. We continue about Mohammedan law. We talk about a preliminary concept. The word Sharia is the general name given to the Mohammedan or Muhammad Rasulullah dispensation and is defined by the doctors as that which would not be known had there not been a divine revelation. The definition of Sharia is broad now to include the revelation made by the Hebrew prophet and Jesus, but their revelation are considered valid only insofar as they have been confirmed by those made through Muhammad. The latter, therefore, are the Sharia par excellence. A second corollary from the above definition is that only what is expressly stated in the divine revelation, or may be inferred from them by analogy, properly comes under Sharia. Matters determined by intellectual process remain therefore outside. Example, the obligation of belief in God or the Prophet is outside of Sharia because it is a matter to be established intellectually. Inasmuch as the prescription contained in the Sharia, to use a judicial analogy, serve as the evidence for the establishment of Sharia law, they have been called by the doctors Sharia evidence or Adillah Sharia, with reference to the source from which these evidence are obtained. The doctors have distinguished four types of Sharia evidence, namely the Quran, the Holy Quran, the Sunnah, or right now is Hadith, the Ijma, and the Qiyas. The Arabic word hukum, or a plural ahkam, is used in various slightly different meanings with no single English word exactly rendered. At least two words will be used to express the Arabic hukum. The word follow, as in this case, and the expression legal result. For example, when the doctor says that the hukum of a sale is the transfer of ownership in a thing from the seller to the purchaser, they mean only to describe the legal result of a sale. According to Shafi'ite doctors or Unified Shafi'i, and the Hanafite or Shafi'ite is not a universal Shafi'i, but about opinion from Imam Shafi'i, and the Hanafi definition and the one adopted in the modern Ottoman civil code or Majalah ignore the way in which this knowledge has been obtained. Consequently, the mere knowledge of the Sharia follower is fiqh, and the person who has this knowledge is a faqih. In other words, a faqih need not be a mujtahid. A faqih, I repeat, need not be a mujtahid. Finally, the term particular indicates that the premise with fiqh uses are not directly obtained from the four Sharia evidence, namely the Holy Quran, the Sunnah, or Al-Hadith, the Ijma, and the Qiyas. The established science or ulum mudawana are first intellectual or aqliyah. In the Muslim evidence is dalil akli atau or logic 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 evidence. Equator the exercise of the intellect and the senses. Number two is traditional. The European intellectual called that is nakliya or dalil nakli. Acquired by way of tradition, the contrast is thus the gap between what we would call the speculative and the historical science. That is the intellectual Europe called the Dalil Nakli or Nakliya is a traditional. They say they would call the because what they're called that is traditional because about a speculative and historical science. The traditional science are first the literary or instrumental, aliyah or lisaniyah. Number two, the Sharia science. The Sharia science are first fundamental or asliyah, pertaining to the first reading of the Quran, B. Interpretation of the Quran or tafsir, C. Hadith or tradition. Number two, deduced or mustanbatah, comprising a dogmatic or itikadiyah, the science of the unity and the attributes of God, kalam or usul ad-din or al-fiqh al-akbar or al-ilm al-tawhid wal-sifat. That is called the traditional science. Then the practical or amalia or fiqh science. The practical or fiqh science comprise first the science of the basis of fiqh, al-ilm usul al-fiqh. Number two, the science of the application of fiqh, al-ilm furu al-fiqh or simply fiqh. That is Indonesian people call that as fiqh contextual. Finally, fiqh related to first human acts which are entirely a matter of divine rights, hukuk Allah, namely a prayer or salat, B. a fasting or saum, C. a legal alms or zakat, D. holy war or jihad, covering war and peace, the latter including the fiscal and other relation of the Muslim state to its non-Muslim subject, and a pilgrimage to Mecca. Number two, human acts which are entirely a matter of private rights or hukuk ibad. Number three, human act of a mixed nature, namely the tithe or usur. This book is created by Nicholas P. Agnides, PhD. published by the AB City Samsia, so the city Java with authority license of Columbia University Paris, New York. In this book, that knowledge to introduction about Mohammedan law or Rasulullah Muhammad sallallahu alaihi wasallam is created by Nicholas P. Agnides, PhD, but we don't know the years about this book is being printed. Our listener right now, we want to try the link about West knowledge and the East knowledge. In this book, just have a date about buying. This book is at 26 September at 1773. So we can have this book maybe if we can get it for being a source for another research output, like something like that, being about a follower of Muslim, maybe that they call a tradition about the trade, that we have a foundation that they the West scientists have four variable or four foundation is Al-Quran, Al-Hadith, the Ijma, and the Qiyas. This is foundation about to justice or make law about economic Indonesian problem right now, about a new follower then being applied at the Indonesian trade, like Bank Syariah Indonesia, Bank Jateng Syariah, and another banking or finance that have used that Islam follower or foundation about to make decision to their product and their server. Thank you. Syukran. Alhamdulillah. Barakallahu ta'ala. Assalamualaikum warahmatullahi wabarakatuh.